Senate custom and tradition not to hold signs during committee hearings. But I do recognize the very sensitive nature of the bill before us, and with the intention of respecting those who have lost family members, we will allow the quiet and respectful display of pictures of your loved ones if you wish. Senator Osmek, you have the bill, Senate File 75. You can begin when you wish.
Thank you, Mr. Chair, members of the committee. Senate File 75 is a bill that I have been working on during the interim and now during legislative session to deal with distracted driving, more specifically a couple of different elements that have occurred that occur in distracted driving. In Section 1, I put forth, and there is an amendment I think we will probably be speaking to fairly soon, put forth a change to the fines that we impose upon people who are guilty of texting while driving. Right now,
Senator Osmek, can I interrupt you one moment? I was misinformed. I thought that we were not going to decide on amendments today. We will consider amendments today and vote on them. The final passage of your bill will be held until tomorrow. And today, at the end of business day, we will simply be laying over your bill. And if it has been amended, it will be in that condition when we take it up tomorrow. So please proceed.
Thank you, Mr. Chair. And I do appreciate doing that action here today because I am unavailable tomorrow afternoon. And I do appreciate the committee taking my bill first today because I do have a family issue that I have to deal with tomorrow afternoon, so I appreciate you taking it up today. Section 1, again, it deals with texting while driving. Texting while driving has become an increasingly problematic behavior that drivers in Minnesota have seem not to take very seriously. And really, I think the fee or the fine that is involved also doesn't put the weight on texting while driving that it should be. Texting while driving is an extremely dangerous activity behind the wheel. You are taking your eyes off the road, and in many cases, people, and I live within the metropolitan area, people are in heavy traffic texting and driving and causing accidents. So we take it from a $50 current fine up to $150 on the first offense, $300 on the second, and $500 on third and subsequent. It also includes on the third and subsequent, it will also include seizure of the cell phone. I believe we may have an amendment maybe to change that. I have kept that in there for a reason, because for people who are violating and found violating the texting while driving statutes we have in Minnesota, there needs to be more emphasis put on habitual offenders. And I'm more than willing to listen to any amendments that might take place on that particular subject. I thought that capturing the cell phone as we capture cars for people who are habitual drunk drivers might be an appropriate step. Sections 2, 11, and 12 deal with forfeiture of that wireless device. Again, that may be something that is up for discussion in this body. In section 5 through 10, we deal with criminal vehicular, we deal with the impacts of non-hands-free cell phone use. If you are using a cell phone or electronic device in a non-hands-free setting and you create bodily harm or you create death to another human being or another driver on Minnesota roads or a passenger in a car or someone who's just minding their own business on a sidewalk, that we impose upon you the same penalties that are imposed upon individuals who are drunk drivers. I honestly wanted to go further. I believe that distracted driving, as it's been reported in many different news outlets and also by the Department of Public Safety, the distracted driving accounts for a very significant portion of accidents in Minnesota. And I think it's time for us to put penalties in place that will get people's attention and start to have an impact on people. Some people who have killed individuals because of their cell phone use have had 5 days in jail, 6 months in jail, 2 months in jail, very suspended sentences in some cases. And I think that that's completely unreasonable. You are not only changing a person's life or extinguishing it, you're changing that family's life. And because of cell phone use, I tell my daughters up front, if I call you and you're on the road, don't pick up the phone. Wait until you get off the road, then you can call me. Call me when it's a safer environment. This still allows people to use a cell phone device with non-hands-free setting, but it does put a penalty on you if that is part of the accident that takes place and creates bodily harm. There's also an additional component in this bill for driver's education. Right now, the driver's ed manual does have that part in the driver's ed manual. This is something that transportation took up. That provision actually says that driver's ed courses will now have to include this distracted driving training or distracted driving curriculum within a driver's ed course, whether it's public or private. Again, that is something that is not necessarily a purview of this committee. I just wanted to highlight that also. With that, members, I'll take any questions and any amendments you may want to consider on this bill.
Senator Osmick, our council has reviewed your bill and is suggesting an A6 amendment. I don't know if you have a copy of that. It's purely a technical bill, but it rephrases certain aspects of the prohibition use, the penalty portion. I don't know if it's been passed out or not. We'll have council pass it out, and then we'll have, we need some assistance for passing out. And then as it's being passed out, we'll have council describe it for consideration.
Thank you, Mr. Chair and members. As the chair said, this is purely a technical amendment, although it looks not to be. The motivation for it is in the fiscal note on page 19, the courts point out that they prefer to have the various penalty provisions kept separate. It allows them to, it allows their data system to work better and thus will cost less money.
And Mr. Chair,
Senator Osmick.
I don't have a problem whatsoever with changing this to make it less costly, but still impose fines that are far more, have far more of an impact on people's pocketbooks than $50 an offense.
Senator Hall, would you introduce the amendment? Yes. Senator Hall moves the A6 amendment. Is there any discussion on the amendment? Hearing none, all those in favor? Oh, sure. Senator Latz, while you're reading it, I'm going to ask a question of Senator Osmick. Senator Osmick, as the penalties are defined, we see on line 1.7, 110, and 112, there's specific dollar amounts for first, second, and third and subsequent penalties. That is not the only cost to these penalties, is that correct?
I believe you are correct. I am not as familiar with all of the legal and additional surcharges that get imposed, but this is directly to the individual fines, plus all surcharges and any other fines on top of it would apply.
Penalties like this also include a surcharge. So this is only a partial cost factor for those that would break this law. There would be a $75 additional fee onto each of these fines. So $150 would have 75 added as a surcharge. So that cost to the driver would be $225. The second one on page 110, or page 1, line 10, would be $375 as a total hit to the driver. And then the other cost, page 1, line 12 of $500 would be an additional $75. Always for each infraction, there would always be a $75 surcharge, just as added information. Senator Latz, is that enough time for you to digest the amendment?
As to the amendment itself, yes, Mr. Chairman. Thank you.
Thank you. Any other questions on the amendment? Senator Hall renews his motion to consider the A6 amendment. Hearing no further discussion, all those in favor say aye. Aye. Opposed? The amendment is adopted. Now we're on the bill as amended. Senator Ralph.
Thank you, Mr. Chair. I have the A7 amendment. I believe this has to be passed out.
All right. Senator Ralph moves the A7 amendment. And we'll wait for that to be passed out. We'll wait for it to be passed out, Senator Ralph, and then we can discuss it with it in front of other people. We'd like to welcome Senator Carlson, who's joining us at our table, and Senator Newman, who's also welcome to sit at our table, as is any other senator. Everyone have the A7 amendment? Senator Osmek, you have the amendment. I'm going to have Senator Ralph describe the amendment, then we'll ask for your reaction to it. Senator Ralph.
Thank you, Mr. Chair. What this amendment does is it makes a couple of changes to the penalty on the, at this point in time, the third offense. It removes the forfeiture of the cell phone, but it in place says that the Commissioner of Public Safety must suspend for a period not to exceed 90 days the driver's license of any person convicted of a third or subsequent violation. This would, of course, be subject to all of the suspension rules. There are things that the person would have to do to get the license reinstated. If they need a license for work or emergency type of travel, they would be able to do that. But otherwise, this would mean that they are off the road for 90 days. We feel that this is put some teeth into the third offense, and in fact, it might even be something we look at sooner. But the third offense is where we've seemed to ramp up the penalties for someone who, if they haven't got it once and they haven't got it twice, now we're going to make it sting. And this would produce a significant, I think, significant deterrence. The second thing that would be involved in this, and this is the second part of the amendment, requires that before reissuing a license, the person that has been suspended, the licensee complete an approved distracted driving course. Course must be 1 hour and include instruction on the laws governing distracted driving and related penalties and the dangers of distracted driving. This is, I believe, as an important component of this whole piece of legislation, the education aspects of it. I applaud Senator Osmek for including education requirement in the driver training courses. It's woefully inadequate at this point. And I believe that if the people haven't gotten the message by now, this is going to make them sit and listen to it. And this is the time when they will hear about people who are harmed and affected by this activity. So I believe that what we're trying to do here is we're trying to send a clear message. And the clear message is don't do it. And if you do, the penalties are going to be severe without being draconian. And I believe that instructing people in distracted driving and taking away their driver's license probably is going to get their attention. So with that, I would ask Senator Osmek what his opinions are, and any other committee members I would have certainly stand for questions.
Senator Ralph, thank you for that. Senator Hall does have a question. I've been informed that your amendment is primarily a jurisdiction of the Transportation Committee. That does not bar you from introducing an amendment in this committee, but nevertheless, just wanted to lay that on the table. I don't know if the Transportation Chair would want this bill back in his committee if this was included in this bill.
Thank you, Mr. Chair, and I have had some discussions with Senator Newman about that, and since he's here, I will let him speak to that.
Well, Senator Newman, are you prepared to make a comment about this? Otherwise, we can move on to another question in our committee.
Mr. Chair, I would comment on it, but keeping in mind I'm not a member of the committee, it's at your pleasure.
All right. Thank you. Go ahead.
I have, Mr. Chairman and members of the committee, been made aware of the A7 amendment prior to the hearing today, and I have discussed this amendment with the minority lead in the Transportation Committee, and the minority lead and myself have concluded that it would not be necessary to have the bill come back to the Transportation Committee if the A7 amendment is adopted.
All right. Thank you, Senator Newman. Senator Hall.
Thank you, Mr. Chair. Senator Rolfe, I sit on Transportation Committee too, so I've kind of gone over this in the past and seen this type of provision to be considered. My problem with it is I appreciate the severity because the action is so terrible. And understanding that, you know that if we suspend a license, we're really going to hurt a family because, you know, their employment may be lost or other things because they can't drive. I understand that, and I also understand that, you know, the other side could be a loss of life. So I'm troubled by it. Would you consider a friendly amendment to change that number of days to 15 days?
I would have to think about it. I think, Mr. Chair and Senator Hall, I think the point is that the loss of the driving privilege does not necessarily mean a person can't apply for a work-related license. Council, maybe you can weigh in on this. I believe there is a provision that allows a person to get a license strictly for purposes of travel to work, and I believe medical. So that would, if that in fact is the case, that would, I think, mitigate to a significant degree the issue of someone losing their license. I really want to send a message here, and I do believe that someone loses their license, that gets their attention. They're not going off to the ballpark, or they're not going off with their friends. You know, they're not driving. And so I feel some lessened amount, that would be fine. I'm not sure what the number would be. I think typically 60 or 90, I think, is what we do. And again, council might be able to give me some guidance on that.
Mr. Backus.
Mr. Chair, members, I think there's quite a variety in terms of the revocation or suspension period. I don't know that there's any one size fits all.
Mm-hmm. Senator Ralph?
Well, again, I started at 90, and that was something I think more just as a discussion. I think this is I wanted to get the conversation started. I certainly feel that any suspension that is significant would have the impact that I and the people that I've discussed this with would be comfortable with.
Senator Dietzig on the amendment?
Yes, thank you, Mr. Chair. I have like two questions. The first one, is there a fiscal note to this? I mean, there's a fiscal note when people get in an accident and if the other party loses their life, but because it says the commissioner shall require distracted driving courses, is there a fiscal note for that, or does the department just expect it to absorb it? And then the other question goes to, is there a reason, because I'm going back and forth between losing your license and your cell phone, because I know a lot of people who, you know, they don't want to lose their cell phone either. So did you weigh those at all? Because I do think losing a cell phone is also a huge impact, and I agree with Senator Hall that if it impacts people getting to work, so I'm just kind of your thoughts on the cell phone versus the
Mr. Chair, Senator Dietzig, I think the thought is here, you take the cell phone away, that's $100, $200, give or take. You can buy a burner pretty cheap. You still got your account. So I think, especially for people who, okay, fine, that's not going to bother them. They'll just go down and buy another cell phone. So I don't think that has the impact of something that actually, I want to inconvenience somebody. I'm very upfront about that. I think you inconvenience somebody without, you know, unduly harming them. I think you get their attention. Having to go down and buy another cell phone, I humbly submit, is probably not a significant inconvenience, especially for someone who, you know, $200-300 doesn't matter to them. They're going to pay a fine. They're going to lose their license. And so I think that's the reasoning that I had in looking at this. With respect to the fiscal note, I recognize there's a cost to this. On the other hand, I think the forfeiture would be a cost. In other words, the cost of administration is probably going to be fairly close, and you have the increased penalties that they're also going to be paying that will go into the system. This amendment was just put together, so I haven't had a chance to check a fiscal note, but just logically thinking, it would seem that the penalty that we're replacing is going to be relatively, and again, I'm not the bean counter here. I don't have an abacus to figure it out, but I think you're going to come out close. Now, maybe our Mr. Turner would have some, and I didn't mean to refer to bean counter, but I think maybe you'd have some input on that.
Mr. Turner?
Mr. Chairman.
I do know that this bill will, if passed tomorrow, would go to the Finance Committee anyway. It's Mr. Turner.
I forgot my abacus as well. Mr. Chairman, any costs related to this bill would be setting up a distracted driving course. I don't know if such a thing exists. We could ask the Department of Public Safety if something does, but obviously the offender would pay for the course, but I'm not sure if the course even exists at this point.
Senator Latz?
Mr. Chairman, I guess I've got a couple of thoughts on this discussion with regard to the amendment. One is, on a first-time DWI, the license revocation is for 90 days, unless you're actually convicted of the DWI, and then it's 30 days. So the administrative revocation under the implied consent law is 90. First 15 days, there's no limited license available. After that, you can get a work permit or a limited license, and I've looked up the statutes under Chapter 171.30. And I think if there were to be a limited license available, council could probably look into this for sure, but we might need to specify in 171.30 that a limited license is available if a license is suspended under this new provision if it's adopted. But to help put it in context, I guess, the proposal from Senator Rolfe is for a revocation or a suspension after a third and subsequent offense under Senator Osmick's proposal, not on a first or second offense. So just that's sort of background on this, I guess. Secondly, I'm more comfortable. I don't like license suspensions generally, but there is a value to them. And I'm more concerned about forfeitures than I am about suspensions, and I'll tell you why. Not everyone's walking around with a $50 flip phone or $100 or $200 disposable phone. Some of the phones, if you go into Best Buy and you sign a contract with Sprint or Verizon or whomever, you're paying $600, $700, $800 for that phone embedded in your monthly contract for 2 or 3 years, however long it is. And losing a phone is not just the hardware. You're losing all the content that's on there, too. So to me, that's like taking a computer. I mean, that's like, you know, that's worth more than this laptop is worth. To me, my cell phone, it's not just a phone. So to me, that's a very serious forfeiture that I could not support. And talk about impacting work. You know, I got a lot of contacts on my phone that would impact my work, my legislative work, as well as my private law practice work, and lots of other information there. So I think that would be over response. The suspension, I'd be comfortable at 90 days because you're at a third offense if you get to that point, as long as the limited license is available during that period of time. And again, I think we probably have to amend section 171.30 to accomplish that. The only other thing I'll add while I've got the floor is that the surcharge that the chair mentioned is the state statutory surcharge, but all local counties add to that. So in Hennepin County, it'd be $78. It's a $3 law library fee. In Scott County, I think it'd be $81. So you're arguing over $3, $6, something like that. But it does add up, and so I'm a little bit concerned that you calculate that aspect into the financial penalty. I think that's something to consider, but that's a discussion beyond the amendment.
Senator Osmek, I'd like to get your opinion on this.
Well, Mr. Chair and committee members, I have had a discussion with Senator Ralph on this. This is also something that Senator Jeff Howe has brought to me. I do think that it is somewhat problematic for seizure of the cell phone because it's not only, as Senator Latz described, it also contains perhaps sensitive private information that suddenly law enforcement is going to have, and you don't know what's going to happen with it. Could it be used against them in a court of law? Just for your information, I also been trying to work on just seizure language so that if there is an accident, that law enforcement would have a short period of time, 72 hours, 48 hours, where they can hold an electronic device in order to get a ruling from a judge that they can hold it as evidence because it may be part of the actual accident. That's not in this bill because having that here would be too much of a scope change and probably sink the whole bill because we would have too many other problems with it. I'm trying to keep it fairly clean. To the amendment, I do not have a problem with the amendment. As stated at 90 days, I wouldn't be opposed to at 30 days instead of 90 days. But I think as Senator Latz said, I mean, this is your third offense. You've done this not once, not twice, but 3 times and been caught by law enforcement. That doesn't even count the number of times you weren't caught because you were doing this activity. So I don't necessarily have a problem with making a statement as opposed to taking the cell phone, making an even more, in my opinion, harsh statement and saying, we're going to start to take your driver's license away from you because your activity behind the wheel is something that we as the state of Minnesota do not approve of. So I don't have a problem with it as written. I think the distracted driving course could be problematic because if there is not a course, we're now creating something new. That isn't what I was necessarily intending on doing. That may be something, if we do include that, it may come out when we go to the Finance Committee because we'll find out on a fiscal note how much that's going to cost. The driver's course, I think, is maybe something more disposable, well-intentioned, but could be disposable. But I think changing it from seizure to 90 days is nothing. I fully support something like that.
Senator Hall? That'll stay close, Senator Hall.
Thank you, Mr. Chair. I never know what the order is, so I had some discussions to do here.
We do that on purpose, Senator Hall.
Yeah, I bet you do. Senator Ralph, again, I appreciate the amendment. I am concerned about both the suspension and the cell phone being taken away. Again, somebody could just buy another cell phone, for $100 or whatever. So it's not the money, it's more of what's in their cell phone. And again, that's the strength of why you're doing it. And I appreciate that, but I wonder if, first off, I know the author of the bill has gone over this, and he didn't put those in, and I appreciate that, but I also appreciate that he probably didn't put them in for a reason in his many discussions. So I do want to trust the author somewhat in this. And I think time will tell. If in a year or two we can see that wasn't strong enough, then we up it and we add things onto it. So I'm concerned.
Senator Ralph.
Thank you, Mr. Chair. A couple of things that I'd comment on. First of all, I had considered the possibility of doing a forfeiture, or not a forfeiture, but a suspension even sooner. In other words, second offense. And that was one possibility. I feel that the message has got to be sent, and that's what I'm trying to do here. With respect to the forfeiture of the cell phone, I tend to agree with Senator Latz that I'm just not in favor of forfeitures. I don't think they accomplish what they really set out to do. We can look at the DWI statutes and even other forfeiture statutes of vehicles. People continue to, their behavior doesn't change it markedly. We're trying to change behavior here, and I think that, and again, I'm not totally hung up here, but I do feel that a forfeiture of a license or a suspension of a license sends a much clearer message, especially if it's over a period of more than 30 or 60 days. You can replace a cell phone pretty quickly, and with most people backing up their cell phones to the cloud, and with most cell phones being encrypted the way they are, a person's information may be exposed, but in most cases with modern cell phones, that's not going to happen, and that person just gets a new cell phone and they've got the information back on their phone right away. So I think that we maybe overestimate the impact that the cell phone forfeiture might have versus the draconian nature of that remedy, as opposed to something that is going to be with them for a period of time. In other words, they're not going to be able to change that other than get a limited license. And I think that's the reason, some of the reasoning. With respect to the driving training, I understand we may not have a program, maybe we should, but I think Senator Osmick has already addressed that to some degree by requiring an increase in the instructional period and time for the driver's training course. And I would think that if we do that, we can lift that right out and create a course that would be fairly easy to do. I mean, certainly it's going to take some time and there will be some cost, and we all know how that works when we start doing this sort of thing, but I think that's an obstacle that's easily overcomable for such an important issue, and I had thought about that a little bit that you raised. I had thought about, okay, is that going to be a cost? Maybe it will. It'd be interesting to know what the department would think it would take to create that, or whoever does control the driver's education, what their opinion on that would be. So those are my thoughts. I'm not totally hung up on all of this, but I thought I'd provide some alternative proposals here that I think, in my reasoning, would be as effective, if not more so, with less of the collateral consequences that you would have with a forfeiture.
Senator Osmick, did you want to weigh in on this at this time? We have another senator that wishes.
My thought is on this, I would probably prefer the amendment on, because I have tried very hard to make this a very bipartisan effort, and I want to take into account Senator Latz's comments, particularly in regards to the seizure problem that he has. I would prefer to have a unanimous vote on the Senate floor as well as in this committee. And I think the seizure probably has more concerns on some members than others. But I'm at I could leave it out. I would just suggest that we have a vote on it and decide on it. My preference would be actually for the amendment.
Senator Ingebrigtsen?
Thank you, Mr. Chair, and I agree with the author the author of the amendment. I agree with the 90 days. And what I don't understand, and I've been out of this for some time, but what is the workings? And maybe somebody here can help me. How does somebody apply for a work permit? How much time does that take? The point I'm trying to make is, if you have it for less than 90 days, it may take more time to even get your work permit, and all of a sudden your time is up. Does anybody have an idea what that takes to get a work permit if it's requested? Senator Newman or anybody from Transportation?
Senator Latz might jump in on this. Senator Latz?
If you have enough time, Mr. Chairman, Senator Ingebrigtsen, if you have enough time to wait on the phone for the understaffed Department of Public Safety to answer your call, you can get a driver evaluator on the line, and it will take a very short period of time. as long as it's already authorized under the statute. And then that's, at least with regard to work permits for DWI revocations, I suspect it would be the same under most circumstances. They would verify that you're under suspension, that you're eligible for a work permit, and then they would get the information from you about the days of the week that you work, the hours of your work, and commute time, and so on. So it should be fairly quick to accomplish that. But I will say, someone along the line here ought to be looking at getting more staff over to the Department of Public Safety, because they are, and I don't criticize DPS at all for this, they are woefully understaffed there, and people end up having to wait a long, long time if they can get through to a driver evaluator.
Senator Latz, we'll be taking up the budget of the DPS department later this session, so.
I do have another question or comment.
Well, at this point,
if I'm
I'd
not
like,
in order.
I'd like to just bring up that our council, since I'm hearing a lot of discussion on a limited license, council has an amendment that may address that. And I'm going to have him describe the amendment now, and then we'll see where we go. Mr. Backus.
Mr. Chair, members, yes, I have language. I think it may be, though, that after the hearing, we may want to take a better look at this with more time, and I might want to redo the amendment by amending Section 171.30, as Senator Latz said. That might be the best way to do it. But in terms of time, I think this language would work, and it would be to the A7 amendment, which has been adopted, line 1.6, after the period, insert, a person whose license is suspended under this paragraph is eligible for a limited license under Section 171.30 without any waiting period. Now, that is also a policy decision for you to make, whether you want a potential waiting period to apply. There are various waiting periods in 171.30, so it seemed that the intent was to have no waiting period, so I thought it might be good to specify that.
Senator Latz, do you have any comment on this amendment?
Well, I guess a few things. One is I'll leave it to council as to whether or not I think we need to also amend 171.30. I know in the DWI statutes, there is a provision for the revocation. That's where the revocation takes place. In the insurance statutes, the revocation takes place. And then there's a separate statute that specifies when limited licenses, and there's a cross-reference in the 171.30. But that can be taken care of at any point that we feel is necessary. With regard to a waiting period, I would not support a waiting period.
Mm-hmm. I would tend to agree.
I think people need to get to work. Mm-hmm. And if this becomes a barrier to people getting to work, or in essence, what it will do is it'll force them to drive without a license to get to and from work, because no one's going to run the risk of losing their job and not being able to pay for their mortgage or their apartment or food for their family or anything over this. They'll take their chances on driving to and from work. The third thing I will say has to do with the length of the suspension. I'm uncomfortable with 90 days personally. I think the message is pretty well sent on a 30-day suspension, which is what you end up with on a DWI if you're convicted of the DWI on a first-time offense. So that's a pretty significant suspension for people to have to work around. Even if they have a limited license, you know, it still means they can't drive their kids to hockey practice. And it's especially an imposition if you're a single parent and you're taking care of your kids and you got to get them to all sorts of places that you won't be able to. So it's a pretty heavy lift for people, even with a limited license. So I think 30 days is plenty to send the message, especially if you're doing this in conjunction with heavier fines on a first and second and a third offense as well. So I'd like some feedback, but I'd be prepared to offer an amendment to change 90 to 30 in the A7 amendment. But we have Mr. Backus's proposed amendment as well, which I'm prepared to offer if it's helpful.
Thank you, Senator Latz. I've been informed that we again are tiptoeing into the jurisdiction of the Transportation Committee with this amendment idea. And perhaps since we have the chairman of that Transportation Committee at the table, Senator Newman, on the A7 amendment, we were talking of the limited license language in order to allow someone to go to work in the event that they violated a third violation and a driver license was seized. If this goes on, this particular bill at this time, would you want this bill to be returned to the Transportation Committee?
Mr. Chairman and members, I think I would like the opportunity to visit with the minority lead in transportation on this issue and think about it myself. The amendment is beginning to change a little bit from what I had anticipated. I did not anticipate, candidly, the distracted driving course, and now we are dealing with the possibility of a limited license. So in view of the fact I believe this bill is going to be laid over, even if the amendment is approved, perhaps I could tell the committee tomorrow as to whether or not I wish it to go back, because I don't think you're going to vote on it until tomorrow. But I would like the opportunity to think about it overnight.
All right. Senator Latsit, on this point?
Well, Mr. Chairman, on the amendment and on this point, the distracted driving course that is included in the A7 amendment, it may or may not already be covered. The way the department does this, the Department of Public Safety doesn't run their own course as far as I'm aware. There are a lot of private organizations that have their courses: Minnesota Safety Council, AARP, Minnesota Highway Safety and Research Center, Minneapolis Public Schools. I mean, there are probably, I don't know, 20, 30 courses, AAA. And I'm looking at a list on the Department of Public Safety's website of approved accident prevention courses. And they got a variety of them. There's an 8-hour classroom, a 4-hour classroom course, an 8-hour online, and a 4-hour online course. So my guess is if such a requirement as is in the amendment were to become law, then these courses would find a way to incorporate this content into their courses so they can be approved by the Department of Public Safety for this purpose as well. And then the driver would just have to sign up for whichever one of these courses is conveniently located for them and fits into their budget.
Sir Ralph?
I would concur with what Senator Latz says, and that I hadn't quite researched all of it, but I looked and found some online that you're talking about. I had kind of also felt that there was already in the education curriculum, there's a short period on it, which under the bill would be expanded. So it was my thinking that this might of itself take care of actually becoming available for that. And I put 1 hour. That was a bit of an arbitrary number, although I felt that this is something that's important enough, and that was why I chose that period of time. With respect to the 30 days, fine. I think that gets the job done. I noticed when I put in, or what I had in the amendment was for a period not to exceed. Now, do we want to put this back in the courts and have them have to decide should this be 30, 60, or 90, or should we just prescribe a period? I guess that would be the question that I would ask. It would be nice if this was a particularly egregious situation that you could hold it for 90 days. So that was all of these things kind of, I didn't want to get too deep in the weeds on my rationale, but that's basically what I was thinking. But I'm certainly comfortable with whatever the committee feels is appropriate in terms of a period of time. I am still very strongly, shall we say, in favor of the suspension. I think it's going to send a message that people want sent.
Senator Anderson.
Mr. Chair, I'd just like to have Mr. Backus reread his amendment for me.
Mr. Backus?
Mr. Chair and members, the amendment would be on line 1.6 of the A7 amendment, which I've been informed has not actually been adopted yet. But the amendment to the amendment would be 1.6 after the period insert, a person whose license is suspended under this paragraph is eligible for a limited license under Section 171.30 without any waiting period.
Thank you.
Does anyone wish to author that amendment? Sure. Senator Ralph?
I would do that, Mr. Chair.
Senator Ralph moves to introduce the verbal or oral amendment outlined by council to the A7 amendment. Everyone understand the amendment? All those in favor say aye.
Aye.
Opposed? The motion passes. We now have the amended A7 amendment before us. Senator Latz.
I move to amend the A7 amendment on line 1.3 by deleting everything after the word period up to but not including the comma and inserting in its place of 30 days.
Could you
I'm sorry,
could you
Mr. Chair?
restate the amendment, Senator Latz?
Restate it?
Yeah. What would you be striking?
Basically
on line
striking
3?
not to exceed 90 days and replacing it with a period of 30 days.
Of 30. Everyone understand that amendment?
Delete.
Is there any discussion?
Yes, Mr. Chair.
Senator Hall?
So what that does is on the third, the third violation, it makes it so that they have a fine, they have a court date that they have to go to, and they will automatically lose driving privileges for 30 days except for a limited license. Do I have that right? Okay.
Yes, Senator Hall.
So the judge here will not have a say in how many days they lose it. It automatically is going to be 30 days.
Senator Latz?
Mr. Chairman, that's correct. Honestly, I don't think I've ever seen a judge make a decision in court as to how long any license suspension or revocation is in a particular case. There's only one situation I'm aware of where the court even has statutory discretion, and that's if there's an accident involving personal injury. Then the court could recommend that, or could direct that the license be suspended for a period. I think that is specified in statute if the court does it. This is my memory of it, but usually the courts don't even get involved in the length of the license suspension or revocation. And if they were, then it would become part of plea bargaining as well with the prosecutors. And prosecutors might not want to get involved in determining how long is the right length of revocation or suspension either. So I think it's easier just to specify it in statute if we're going to do it.
Senator Anderson?
Thank you, Mr. Chair. Senator Osmek, the proposed amendment for 30 days, your reaction?
Senator Osmek?
Mr. Chair, Senator Anderson, I appreciate Senator Latz's thoughts on that change, and I support that. I would only go on to say one additional change that might be considered on line 1.13. We specify that the course must be 1 hour and include instruction on. You may want to consider adding or striking or doing an insert saying that the course must be at least 1 hour, because as described by Senator Latz, there's a number of these courses that are over 4 hours, 8 hours. I think by specifying it has to have at least be a 1 hour course is probably a little bit better language, but I'll leave that up to the committee.
Senator Ralph would move, or let's see, we're on Senator Latz's amendment right now. I think we'll take Senator Latz's amendment first. Any further discussion on Senator Latz's amendment? Everyone understand the amendment? Changing 1.3, striking the words not to exceed 90 days, replacing it with to read for a period of 30 days, comma. Hearing no further discussion, all those in favor say aye. Aye. Opposed?
No.
Chair is in doubt. All those in favor, raise your hands. 2, 3, 4, 5. All those opposed, raise your hands. The motion does prevail. The amendment is adopted. Now we'll move on to the language that Senator Osmick suggested on lines 1.13. Senator Ralph moves that on line 1.13, after the word "be," to insert "at least." Does everyone understand that amendment? No further discussion. All those in favor say aye.
Aye.
Opposed? The amendment is adopted. Is there any further discussion on the A7 amended amendment?
Mr. Chair,
Senator Anderson.
did you move that last amendment?
It was
Senator Ralph.
moved that amendment.
Thank you.
Any further discussion on the A7 amendment? Senator Latz.
I'm just trying to take a quick cut through it and see what sections are deleted. So maybe we could get a little clarification. Sections 11 and 12 are deleted. Were they only because they were connected to the forfeiture provision? Is
Mr.
that-
Backus?
Mr. Chair, yes, it's 3 sections being deleted, 2, 11, and 12, and they all have to do with the forfeiture.
Thank you.
Any further discussion? The amendment is before us. Senator Ralph moves the A7 amendment as amended. No further discussion. All those in favor say aye. Aye. Opposed? The amendment is adopted. Any further discussion on this bill? Any further amendments? Senator Dietzick.
Thank you, Mr. Chair. And some of this might be veering into transportation, and so I apologize. But some of the questions that I have were, is hands-free setting defined anywhere? Again, that might be a transportation issue. How do you, so you have in here several lines, like on 515, in a negligent manner while the driver is operating a cellular phone or other electronic device in any manner without the use of a hands-free setting. And so I'll give an example. So in my car, I have hands-free where I can, literally do a, so-and-so call or call this number, or I have a one-touch of, answering the phone. And I can have both hands on the steering wheel. But I have a large minority community in my district that has, they literally wear their cell phones. So I see them driving with both hands on the steering wheel, but you can see a cell phone here. They're just not holding it here. Is that considered hands-free if they are actually, again, I can see both hands on the steering wheel, but it's up here. So hands-free isn't, I Googled it and I can't find it defined. And so how do we know? Is it literally if you have some Bluetooth device connected? What does that actually mean?
Sir Osmick, I'm not sure if Senator Dietzick's question pertains to this bill.
I don't either,
Or maybe
so-
more appropriate for Senator Newman's bill tomorrow. But
It's
Senator
just-
Osmick?
Well,
It's used in the language.
yeah, Mr. Chair, Senator Dietzick, I agree that I don't believe we necessarily have something specific in statute that defines what hands-free is. Hands-free in my layman's terms, and I'm not a lawyer and I don't pretend to be one, is where you're not using the device with your hands. That would apply to a Bluetooth earpiece. It would be in a speakerphone setting. But if you are actually putting it up to your head and then packing it with something, I'm not sure that that meets the spirit of hands-free, because you are still having to use your hand to put it into position, as opposed to you get in the car, you have your Bluetooth, or you have your, you actually have in some cases, some cell phones have software where you can actually speak to the phone to say, text this, or et cetera, et cetera. That is true hands-free. So I think, I'm not sure if we have to define it. I think it's somewhat understood what a hands-free and non-hands-free would be. But my interpretation would be, and of course that would be up to a judge to determine in court if it gets there, that if you're bringing the phone, putting it here, jamming it, that is not necessarily a hands-free situation.
Senator Dietzich, I was informed that this bill does have a reference to hands-free phone on page 9, line 14 of this bill. I do believe that the term hands-free being undefined may create a problem. Senator Osmick, I'm always cautious to let a judge define something in a bill that we pass. So perhaps Senator Newman or you might come up with an idea or a definition of what hands-free actually is. And so we'll just put that as a notation for tomorrow. Any other discussion regarding this bill, Senator Ralph?
Well, I'd like to, again, follow up a little bit. I think there's several places in this bill where they refer to, anytime we refer to the enhanced crime, we talk about are there electronic device in a manner without the use of the hands-free setting. And I mean, this is not just in one place. And in my understanding that the original intention of this bill was not to change the law with respect to the definitions and the use of a phone in a hands-free versus other types of mode. So I guess that's a little bit problematic, because one of the issues that I have with this bill, and I don't want to take too much time here, but I do have a problem with the idea that what we've done here is by the provisions of this bill, we've turned ordinary negligence into a crime. Now, there are some cases in statute where that happens, but they're rather egregious conduct, not to minimize the conduct and the results of this conduct here. It's just, I think, as we go forward, we have to have a clear picture in our mind of what we're doing here. We're talking about creating a 10 or possibly even 20-year penalty on someone who is involved in a vehicular homicide. And the issue that I have with that is two-part. First of all, to automatically have that occur ignores the possibility that the failure to use a hands-free or the use of the electronic device may not have contributed to the accident. And without specifying that in the bill, I think we may run afoul of some unintended consequences. And I want everyone to understand, I am not against being very harsh on people who do this sort of thing, especially when it seriously injures or takes a life. But I do think we have to be very careful as we go forward when we criminalize ordinary negligence, and that's what we're talking about here, without further expansion of the definitions that we're talking about here. Because as I read it, it simply says, operates in a negligent manner while the driver is operating a cell phone or other electronic device in any manner without use of the hands-free setting. We're talking about ordinary negligence, and we're not talking about any sort of proof of causation that the cell phone actually caused the accident. Now, we assume that in most cases that it contributed, but I think we have to be very careful of a precedent of criminalizing ordinary negligence. As far as I can tell, and I haven't looked extensively, but I don't find any other state in the union that does this with distracted driving, that actually makes it criminal for the ordinary negligence. Now, if you're sitting up there taking a selfie and driving in something, I mean, I think that could be considered gross negligence, and I would like to see that standard applied here. And I guess I throw that out for discussion, because I do think that we get into a very, very deep hole here if we are going to start saying that just because of your very presence in a vehicle, for example, of a cell phone, that you're now going to be convicted of a felony, and a fairly severe felony. This is not a short time. I think that the deterrent effect is something we need to look at. That's what severe penalties are for. Is we have to penalize, but we also have to deter. And can we accomplish that without criminalizing what would otherwise be ordinary activity? And that's the question that I raise. And I'm very much conflicted on this, but I feel that this is something that we have to be very careful. That's a very, very, very deep hole that we would be digging into.
Senator Osmick, any comment?
Well, and I'm not a lawyer and I don't pretend to be one. I try to do things that I think are relatively common sense. And it's a point well taken that with the defining hands-free should be something that myself and Senator Newman deal with. I look at this somewhat, and the reason I put this into the drunk driving or just the DWI statutes is because the result is the same, in my opinion. You're either creating great bodily harm or you're creating death of another person. And while I understand the intent issue, and that's why I haven't gone farther, which would include chasing the last Cheeto at the bottom of the bag, yelling at your kids in the back seat, all kinds of other things that create distracted driving scenarios. I've tried to split the baby in half of creating a penalty if you are found to be doing a behavior but are still allowing the behavior to happen. That you still can use the cell phone in a hands-free setting, but if you create, or if it is a component of a accident where bodily harm or death occurs, that this enhanced penalty comes into play. I don't want to claim that this is perfect in any way, but it does put into statute that people aren't going to go to jail for 5 days anymore when you're killing people on the roads. And I think the advocates that are behind me are incredibly frustrated that we as a state don't take a position that is tougher on individuals who are doing something with these devices that they can just stop doing or wait until they get off the road. So I'm willing to listen to any additional language changes, but I think the direction I'm trying to go is to get penalties to actually meet the damage that is being caused to society.
Is there any further discussion? Senator Latz.
Thank you, Mr. Chairman. With regard to having a definition of hands-free, I mean, it is in the definition of a crime that we are considering, so I think that is squarely within the jurisdiction of this committee. And were this bill to receive a vote to move on, I would really hate to see it move on without a clear definition of the terms involved in the crime. So I think it would be incumbent upon us, before we take a vote tomorrow, to have a definition of hands-free, because that is something that's our responsibility, not transportation or any other committee's responsibility. Senator Osmick said he wants the enhanced penalties because of the result. And we've got to be careful, I think, about that, because if you're driving down the road at perfectly as safe a speed as you think you can be going and you hit a patch of ice and spin out, it might not have been your fault at all. Although you might say driving any speed on the highway today is negligent. None of us probably should have even driven here, given the road conditions. But if you define it only by result, we could never live with that kind of a situation. There are, in fact, accidents kind of a misnomer. I prefer to call them crashes because accident gives a suggestion that there was no poor driving behavior involved, or that there was. Sorry, accident says there was no pure driving behavior involved, or bad driving behavior involved. So these aren't really accidents. If you're driving drunk at a .30 and you hit a car and kill someone, that's not an accident. That happened because you were driving drunk and you were incapable of controlling the motor vehicle safely. But if a crash occurs, if you look at the way the statute's written, and it's not just the DWI statute here, this is the criminal vehicular operation statutes that is proposed to be amended in this bill, 609.2113, and when you're looking at 2114, 211, well, 5, I assume. There's a variety of ways that you can get to the enhanced penalties under criminal vehicular operation. One of them is simply in a grossly negligent manner. And I presume what happened, well, the others are negligence in combination with some other factor, being under the influence of alcohol or controlled substance, being under the influence of a different intoxicating substance, having any amount of a controlled substance if it's a Schedule 1 or 2, leaving the scene of an accident, regardless of negligent driving behavior, just leaving the scene, and basically driving a defectively maintained vehicle. So it's, at least for the controlled substance and alcohol related, there's the negligent driving plus being under the influence, which is 2 elements of the offense. The assumption is being made here, and I don't think it's a bad assumption statistically, is that operating a cell phone using your hands poses the equivalent risk of driving while under the influence of alcohol or other controlled substances. I think there might have been some testimony in transportation on this. I suspect there was, but I think the statistics are showing nationwide that it's as risky to drive while you're talking on your cell phone, let alone doing other things on your cell phone, as it is to drive at a .08 or higher alcohol concentration. I mean, it's that risky of behavior. So I think there's an assumption being made here when we put this combination together, negligence and operating a cell phone without the use of hands-free. The only other point I will make, and I'm not even sure where I want to go with this for sure, because I'm kind of on the fence with what Senator Ralph said. I'm very concerned about that impact. But the only other point I'll make, just maybe a little bit for clarity, and Senator Pappas pointed this out to me too, because we have a letter in material we've received from a family that lost a daughter, I think it was, to a distracted driving situation in a car accident, and they didn't get much of a penalty in the criminal case because presumably it was a misdemeanor level penalty. Presumably then the prosecutor didn't think they could prove gross negligence because there wouldn't have been any of the other provisions in the CVO statutes that would have applied. So I don't know if one could prove gross negligence by the fact that someone's on a cell phone. Maybe juries today, knowing more than they did 5 years ago or whenever that time was, would feel differently. Maybe we have more statistics now that a prosecutor could use to back up a claim of gross negligence. So I'm kind of uncertain where to go with what Senator Ralph's comments were. I've got a lot of the same concerns. I know we're not taking a vote today, so maybe it's something for me to chew on overnight. But those are my thoughts for what they're worth, Mr. Chairman.
Thank you, Senator Latz. Just as a reference, tomorrow's bill, Senator Newman's bill on hands-free driving, is all about the definition of hands-free. And a solution may be as simple as a cross-reference of this bill to tomorrow's bill and the definition that we find here. And that's why we're considering both bills in a relatively short time, so we can kind of keep that continuity of discussion going. Otherwise, if we spread them out too far, we would have difficulty with it. So we do have tomorrow to maybe come up with maybe a solution or to adopt the language of Senator Newman's if it meets our bar.
To that point, Mr. Chairman, it would be really helpful for me if Senate counsel or someone else with greater knowledge of this than I have could help me understand how these two proposals might interact with each other if they are both adopted. I'm concerned whether there be some overlap or some conflict or maybe complete inconsistency of adopting both. So I'd be interested to have some feedback from our professional staff or testifiers who might know about this or someone else. It doesn't make sense to adopt both bills. If both were to become law, could they work together? Or would they conflict each other out in some way?
Mr. Backus.
Mr. Chair and members, That's a very good question. They both amend the exact same provision of law. One, Senator Newman's bill deals basically with, using a cell phone to make calls and things like that. And Senator Osbeck's bill deals with texting while driving, but it's the same subdivision of law. So any of the penalty provisions that you're grappling with today will also, if they both are enacted, apply to Senator Newman's language. So the bills are very closely interrelated. I think at least as the bills came to this committee, they're not inconsistent. So I think what would happen, at least again coming into the committee, is that if the legislature passed both bills separately, they essentially would be merged. But I think, again, it would be good for the committee just to keep an eye on the fact that the two bills are so interrelated, so that if you do one thing in one bill, for example, a definition change, it might affect the other bill.
Any further discussion? Senator Ralph.
Just one last thought on this, and I just want to make sure everybody understands the distinctions that we're talking about here. Gross negligence is a conscious and voluntary disregard of the need to use reasonable care, which is likely to cause foreseeable grave injury or harm to persons or property, or both. It is conduct that is extreme when compared to ordinary negligence, which is a mere failure to exercise reasonable care. I think we have to keep those in mind as we go forward and how we're going to work with these definitions. We seem to be somewhere in between. Obviously, reasonable care could be said, don't text or cell phone while driving. That'd be reasonable care. And if you don't exercise that, you're guilty of some kind of negligence. The question becomes, and again, when we're dealing with criminal statutes, we're dealing with intent. And we have to keep that in mind. I mean, I want tougher penalties on this stuff. I just want to be very careful how we do it.
Senator Osbeck.
Thank you, Mr. Chair. Just sort of wrapping up a comment that Senator Latz had about a definition of hands-free. Our friends in the other body actually have, I think, some pretty good language that I will meet with Senator Newman on, and this may be exactly what you're looking for to define, and Senator Dietzig too, defining what hands-free actually means. So we will work on that and have that available, and anything that comes up tomorrow regarding that definition has my approval.
Any further discussion regarding this bill?
Mr. Chair.
Senator Anderson.
Thank you, Mr. Chair. Senator Osbeck, in your delving in and doing work on this bill, and how many specific hands-free, or I should say distracted driving situations did you find in your background checking as to the state troopers or local law enforcement having pulled over and just given a minimum, as Senator Latz had just said? How many of them would be, based on this bill that you're bringing forward here, this legislation, how many would end up being in front of a court system? Give me an estimate of how many would be.
Senator Osbeck.
Mr. Chair, Senator Anderson, because of the way, and I did look at the number of offenses, particularly when it comes to death, and the mitigating circumstances that are identified when law enforcement puts those onto a report. Distracted driving is a component, but it doesn't necessarily parse out cell phone was used or other components specifically. I just found that it was just distracted driving, and in that particular portion it was a mitigating factor in some place. I think it was between 15 and 20%. And I think that was a low number that I saw, that for just deaths, that was the number of occurrences where that took place.
Senator
Mr.
Anderson.
Chair, 15 or 20% of what?
Senator Osbeck.
Of deaths, incidents that occurred, deaths on the highway.
Were from distracted driving.
That had distracted driving as a component. There may have also been weather involved. There may have been, there's so many different additional components that can be included in an incident. Distracted driving is a component, but it may not necessarily be the component. or it may have been completely that, but you couldn't parse out cell phone use in it, which is the part that I was really trying to go after.
Mr. Chairman.
Senator Anderson.
Thank you, Mr. Chairman. Senator Osmak, so 15 to 20% of deaths on the roadways here in Minnesota, 2018, 2017, whatever the years would be, whatever amount of time, how does that burden the courts?
Senator Osmek.
I mean, what we're saying here is we're adding extra language here, and we're making extra penalties and other things that will be needed by the courts and needed by law enforcement and needed by attorneys and so forth and so on. How much do you, maybe you don't have an idea on what that would be?
Senator Osmek.
Mr. Chair, Senator Anderson, no, I don't have a specific number or specific amount of impact that it would have. Because these would be cases already taking place. This would just be an enhancement that would be put on if this condition was found. So the number of cases I don't think would increase. It would be the penalties. In my case, it would be the penalties that would be more extreme, would be increased significantly, and the sentences would be also impacted on those people. There would still be the same number of cases, just different penalties.
Let me ask Mr. Turner if he might have some information on the impact on the courts. Mr. Turner?
Yeah, Mr. Chairman, members, there are some misdemeanors that will be taken off the payables list, which will require...
Pull the microphone closer to you. Mr.
Which
Turner.
will require a court appearance, but also there'll be felony enhancements. These are cases that are already in front of the court. In the fiscal note, the courts don't claim that the added activity would be too burdensome for them. However, the public defender has weighed in and said that while they have claimed 14 new FTEs, I think their methodology needs to be gone over. And I'm going to be doing that over the next day. But within the fiscal note, it's the public defender that provides the concern.
All right. So,
Oh.
that's an important message to listen to. Sir
Excuse
Ralph?
me, Mr. Chair.
Thank you, Mr. Chair. I have just one more kind of a, I don't know what to call it technical, but just some more information to throw into the barrel. I see that we have Judge Small here, and I see him wince. Any thoughts in terms of the sentencing guidelines and how this would fit in terms of a first offense when a person is brought forward with one of these felonies? Do you have any knowledge of how that would be treated on the grid? Or is there anyone else that might have a better sense of that?
Judge Small, we really weren't planning on taking outside testimony today, but if you would like to hold for an answer for tomorrow, you're welcome to do so.
I'll be back tomorrow.
All right. Thank you. Mr. Backus.
Mr. Chair and members, to try to answer the question, I mean, the Senator Osmak's bill, the only provisions that would be relevant for the Guidelines Commission would be the provisions for the criminal vehicle operation. And I think the assumption that everybody is making is that the new offense for each level would be treated the same as the other offenses within that level. So, for example, for the Section 5, which is the criminal vehicle operation, the presumption is that would be a severity level 8 offense, which is a 48-month presumptive commitment at 0 points. But since it fits within the current crime, the assumption is it will be treated the same.
Judge Small is giving me an indication that's exactly what he was going to say. Senator Anderson?
Thank you. This bill is to hopefully lessen the amount of distracted driving on the roads right now. Right now, with the penalty, it's against the law to text and drive right now. Any proof that what you're going to do with this bill is going to lessen the amount of distracted driving on the road?
Senator Osmer?
Thank you, Mr. Chair. Senator Anderson, well, one thing it will do is increase the penalties, but I think this gives law enforcement, and this is probably just as important to the penalties themselves, gives law enforcement another avenue to publicize how dangerous certain activities are behind the wheel. We always see the amber boards talking about wearing your seatbelt, and that we have public service announcements that are on TV and on the radio. This provides another avenue by which law enforcement can say, if you do this and you are using a cell phone, not hands-free, and you get in an accident and kill someone, you're going to go behind bars for a while, for a significant amount of time, not 5 days, not 5 minutes, not 5 weeks, a long time. And I think it gives them the ability to further highlight how we should put the cell phones down and stop using them, or better yet, explaining how dangerous a lot of activities are. I would rather have gone across all distracted driving, but I know the words intent are important in this committee, and I can't get past that hurdle. But I think this gives law enforcement another tool to continue to publicize this type of activity as being something that's a concern for us here in the state of Minnesota.
Senator Latz?
Mr. Chairman, it sounds like you may be taking testimony tomorrow from persons other than the authors. So maybe my question is more of a setup for tomorrow. But my question has to do with the concerns I've heard raised by law enforcement about the ability to actually enforce the law when the question is, was the driver texting while driving, or was the driver doing something else, which they are allowed to do under current law, on their mobile device while driving, like operating their GPS or surfing the internet, I think is still allowed, if I understand it, under the law while driving, because it's not texting, unless the language here is compose, read, or send an electronic message is the current statute that we're amending, 169.475, with the penalties. So anything on the phone other than sending, reading, or composing a text message, I suppose, or a message on WhatsApp or some other messaging app is still allowed under state law, as I understand it, unless it could be considered to be gross negligence at some point. And I'm sure we'll get to that conversation tomorrow, because I think that's part of the gist of Senator Newman's bill. But it would be helpful to me to hear some testimony about law enforcement, because
Senator Latz, we will be inviting law enforcement to give testimony. We're kind of limiting some of the other testimony because it was done in the Primary Jurisdiction Committee of Transportation. So
but we are,
hopefully
we are being called upon to pass much more severe criminal penalties, and ease of enforcement or proof of a violation of law is pretty important, I think, for this committee's jurisdiction as well.
We'll have law enforcement here. Any further discussion? We're getting close to the end of our time period. As we end, Senator Osmek, in listening to this bill, I had one question, and it refers to the distracted driving course. The distracted driving course now as described must be at least 1 hour, but it's upon the third or subsequent violation. Do we have to wait for the third violation to have a distracted driving course? I would think that we would want that distracted driving course somewhere up on the first or second offense, so we never get to the third offense. And that might be a question that we can consider tomorrow.
Mr. Chair, I wouldn't necessarily have a problem with putting it up into the second offense. And if this body does decide that that's the direction they want to go, I don't have any concerns about making that adjustment.
All right.
Mr. Chair.
Senator Anderson.
I would probably even go as much as to say, that's something that should be discussed as a normal opportunity in the regular driving instruction as a distracted part of that instruction, rather than even have it. I mean, it can be in here, but I think it needs to be enhanced to even as a preventative.
Sure. Senator Osmek, is that correct? That
Mr.
it's
Chair, Senator Anderson, that actually is part that we are not discussing in here because that section was more to the transportation section of the bill itself. But that is part of the bill. The third component is including distracted driving in all public and private drivers training courses. It's in the manual itself, but this would instruct the commissioner that they will have to have that as part of distracted driving training in the courses themselves as part of the curriculum. So that is something we just haven't, this is not the purview for this particular committee. It was discussed in transportation.
Senator Ralph.
Just a quick question, procedurally, I guess. If we were to make this the second or even possibly the first offense, can that be done without a mandatory court appearance to force someone to take the distracted driving? I don't need the answer now since we'll be doing this tomorrow, but I think it's an issue we should think about because it might affect the way we go about it.
I'm sure we'll have other questions tomorrow. There's no further discussion on this bill. Senate File 75 is laid over. There's no further business before this committee. We stand adjourned.